My name is Attorney Barton Morris from the Law Office of Barton Morris. We deliver services to businesses and corporations, small businesses in the state of Michigan with our offices in Troy, Michigan. This video is about partnership disputes, which is basically about corporate law and limited liability corporations. LLCs, even regular corporations, generally have or often have more than one owner. So if they have two or more owners, they're generally referred to as partners or co-members or members. And of course, when there's more than one partner, there's the potential for a dispute. It happens regularly, and it is a good idea to keep these things in mind that I'm going to talk about in order to avoid disputes, or at least do things that will make disputes easier to resolve, because they can become difficult, quite litigious, and problematic, which can be avoided with some very helpful tips. The first tip, the first most important thing that I think is necessary in order to avoid a partnership dispute is to have an operating agreement or a membership agreement or a shareholder agreement. What that is, in the sense of an LLC, a limited liability company or limited liability corporation, is the agreement that governs the operation of the business. It identifies who the managers are of the business, and it identifies who the members or the owners are of the business. Oftentimes, when there's only one owner, many people choose not to have an operating agreement. But when there's more than one owner, it is important to have an operating agreement, because the operating agreement will illustrate who is responsible for management of that business, and also who are the owners. So, for instance, in any agreement, in any business, there's going to be owners. How is it that you prove who those membership interest shares are owned by, and in what percentage are they owned by? Well, that's done with an operating agreement. The operating agreement might identify one person as a 60% owner and another person as a 40% owner, or perhaps they are 50-50 owners. The point is that when there's an operating agreement, it spells it out in writing. So you can imagine what then the difficulty may be if there's not an operating agreement. And I run across this all the time, of course, only when there's a partnership dispute. Because when there is a dispute, for instance, when there's a dispute as to who owns more membership interest than the other, or who has more managerial rights, then there's a dispute, and if there's no operating agreement, it becomes more difficult to make a determination as to who owns what, or who has the right to do what. And so the very first most important thing, again, that I recommend for any LLC, particularly ones with partners, is to have an operating agreement. Same thing can be said for a regular corporation, in that it should have a shareholder agreement or a management agreement and bylaws. Generally, in a corporation, the corporate entity is going to be managed by a board of directors, and they should be governed by a set of bylaws. And the shareholder agreement will identify who owns what shares and what percentage to the total amount of outstanding shares. It is important to have these things in writing. And it's important to keep them updated. I have seen situations where there's a change, and the members of the board or the management seeks to change something, and they intend to change something that should be reflected in the operating agreement, but they don't do it. Next thing you know, we have one party relying upon the terms of the operating agreement, while the other party says, no, we made changes, yet they weren't reflected in the operating agreement, or another operating agreement was created and it wasn't the first one wasn't referenced. These are the things that cause partnership disputes. And more often than not, these partnership disputes end up being litigated. And not only are they litigated in the court of law, but sometimes these agreements call for arbitration clauses. They have arbitration clauses. And so if the parties agreed to litigate these disputes not in court, but in arbitration, then perhaps it might be they might be compelled to make these arguments in arbitration. When talking about partnership disputes, one of the most common types is the minority membership oppression. What that means is there's going to be sometimes some members or some owners that own a minority share and others that own a majority share. And because of the sheer nature of the fact that somebody owning a majority share has oppressive potential to oppress the minorities, that can give rise to a minority oppression lawsuit or claim. As an example, perhaps the majority members are also managers of the business, which is very normal, and the minority owners are not managing the business, yet they have perhaps contributed some capital or some money in order to purchase their minority membership interest, and then they feel as though that their minority interest is being oppressed. Perhaps the owners of the company or the majority owners of the company are managing the business that are seeking to promote themselves or benefit themselves more than the minority owner. In fact, to the degree to which they feel oppressed. This is a potential violation of the operating agreement and a violation of state law. The state of Michigan has laws that prohibit minority membership oppression because of the very nature of the situation. So therefore, the state of Michigan creates a law that seeks to help the minority members. One way that Michigan law seeks to assist minority members is to give them rights of discovery. That means that minority members, minority shareholders, members, really every member, even if it's a majority member, has the right to discover the books and records, the financial books and records of the business. That could be the general books and records, or it could be anything specific. So, for instance, it could be in general, like the balance sheet or the profit and loss statements or the monthly statements that are prepared by a CPA. Or there could be something specific about particular contracts or particular distributions. If there's been unequal distributions that are in violation of the operating agreement, then the minority members should have the opportunity to discover these things, to investigate these things. Otherwise, what control do they have? They should have the opportunity to be able to look at these things. In fact, when we draft these agreements on behalf of minority members or negotiate something on behalf of a minority member, we always will offer to that individual or that membership interest the ongoing service of continuing to discover these financial records. They're entitled to them on a regular basis. So it's not just once a quarter or once a year. We can ask for them on any reasonable basis. Perhaps once a month might be appropriate. It depends on the business. Perhaps once a quarter is appropriate. I'd say that would be the minimum. Every quarter, I believe a minority member should be in demand and have the ability to access the books and records to ensure that their membership interest is being protected, to ensure that there is no minority oppression, and simply just to keep the majority members on their toes. If they know that the minority members are going to be looking at the books and records on a regular basis, which is their right to do pursuant to Michigan law, then naturally that might put them in a position to be a little bit more honest about their actions, about their managerial actions and their decisions. So minority members should keep an active role and interest in just protecting their membership interest And even though they may not be managers, they may not be running the day-to-day, they certainly have the opportunity to continue to monitor the business and its transactions to ensure that they're protecting their interests and to ensure that there is no breaches of fiduciary duty. The next topic would be breach of fiduciary duty. What that means is that the state of Michigan, state law, requires that all members act in what is the best interest of the business. As an example of a fiduciary duty, all members have the obligation to do what's in the best interest of the business. If a majority member who is also managing the business, if they were to do things that, for instance, perhaps would give them a personal benefit, an unequal benefit that perhaps is not shared amongst the membership based upon their membership interest, we call that self-dealing. If, for instance, let's say a member may have a business, another type of business, and they're funneling this the company's business or contracts to their own business, well, that's called self-dealing. And if that's happening without full disclosure of the rest of the membership, that could be seen as a breach of their fiduciary duty. They're doing something and taking actions on behalf of the company that is self-dealing or benefiting themselves and not everybody else. Now, that doesn't automatically mean that it's a breach of the fiduciary duty. Perhaps it is in the best interest of both companies for that business to operate. Just because that majority member may be benefiting from it from both sides doesn't mean that it is an automatic breach, but sometimes it is, and that has to be evaluated. Not only majority members have duty of a fiduciary nature to the company, but minority members do as well. The difference is that oftentimes minority members don't also have managerial authority, meaning they're not running the day-to-day, and so their decisions aren't really affecting the business and the best interest of the business. And so it's, again, another example of majority membership oppression of minority shareholders or minority members. Breach of fiduciary duty is something that causes membership disputes and partnership disputes. Speaking of duties that are owed to the membership, all members have an obligation not to do things that are not only not in the best interest of the company, but they have an obligation to do things that are explicitly not authorized by the operating agreement. For instance, the operating agreement may call for certain activities to be punished with the threat of expulsion. For instance, most operating agreements identify the act of any type of embezzlement or any type of misappropriation of funds to be acts that are potentially punished by expulsion. If another member were to discover it, they can initiate an action of expulsion and perhaps even initiate an investigation that might be conducted by a third party as outlined in the operating agreement in order to identify any type of acts that may cause expulsion. Expulsion is something that happens regularly in these agreements and in these in the operating agreements and just in practicality, because sometimes people don't act in the manner of which that they should. Not only in the sense of embezzlement, but also in self-dealing or in misappropriation of funds, in taking actions that aren't authorized by the membership. There's a number of things that can be identified in the operating agreement as cause for expulsion. If there is expulsion, then there generally is going to be a acquisition of that individual's membership interest shares or their membership interest. What that means is that it causes a forced distribution of their shares. So if somebody owned 40%, let's say, of a business, and that person did something that required expulsion, well, that 40% has to go somewhere, and it may be distributed in a number of different ways. It may be distributed equally amongst the remaining ownership interest based upon their current percentage of their ownership interest, or it could be offered for sale to certain individuals as the right of first refusal, or it could be offered for sale to a general class of individuals. It depends on what's in the operating agreement. It may force remaining members to purchase the membership interest. And then the next question becomes, well, at what value? What value is the individual who's being expelled? Is their membership interest being purchased for? It could be for book value, or it could be for market value. Book value attributes an interest or attributes a value to those shares based upon the value of the business as it exists in the books, as opposed to market value, where the market determines the value of the shares, meaning that what would somebody pay for those shares, because just because the book value may be much less than what the market value may be. And that by itself could be the basis of a membership dispute or a partnership dispute. How do we value the shares, and what is the value of the shares? If somebody is expecting a large amount of money for the exchange of their shares, particularly if somebody's being expelled, oftentimes others may believe that they don't deserve that money because of reasons why they may be expelled. And this is, of course, this can happen regardless of whether there's an expulsion or whether simply there's a sale, some other forced sale of the membership interest. The value could be book value or market value, or a combination thereof, or a multiple thereof. Generally, it's going to be identified in the operating agreement. If it's not, then it's going to be set by case law and the circumstances. The operating agreement will also identify the transferability of shares. Sometimes the agreement will restrict the transferability of shares, meaning that I could be a member in a company and I want to sell my shares. Well, the agreement may preclude my ability to sell my shares to anybody else. Oftentimes, those agreements restrict that because they don't want just anybody else becoming shareholders in their company. On the other hand, the agreement could permit the free transferability of shares. So again, that's another provision that is going to be within an operating agreement, and it also illustrates the importance of the operating agreement and all of the different provisions that can be contained therein. Another provision within the operating agreement concerns the amount of voting rights that a member shall have. There could be voting on a number of different issues, to sell a portion of the business, to buy something, to sell something, to operate in some fashion, to acquire another business. There's obviously a number of different things that can be decided, and some of these things are decided by the management, but others are decided by the membership as a whole. And oftentimes we see agreements that identify somebody's voting rights in precise percentage of the amount of membership interest that they have. And so if they have a 20% membership interest, then they have 20% voting rights, 20% of the whole. It could be measured as a number of units, or it could be measured as a percentage, but it's often identified and specified by the amount of membership units or membership interest, percentage membership interest that a party has, that oftentimes is the amount of voting rights that they have. But it isn't always. We've seen plenty of times where the membership interest is not equal to the voting rights. We have seen situations, and we've written situations, where the voting rights perhaps are equal, maybe let's say there's 2 or 3 members and they have different membership interests, but they are all managers and they wanted to have equal voting rights. It's completely acceptable and common, and permissible and written into the agreement if in fact that is what the membership wants at the inception of the agreement. In fact, it's a good idea to ensure that there is some manner of a tie break, because envision the situation where there are 2 members, both of them are managers, having equal voting rights. Well, that effectively gives each individual veto power on the other, because if they need unanimous decisions, unanimous agreements, with one person then can vote down anything, and that will lead to a partnership dispute, because if the issue is big enough, that might lead to litigation. There should be something in the agreement that permits a tie break. Perhaps a third party then has the right to make a decision, or perhaps one party simply just has more of a voting right than the other party. Because if they both have equal voting rights, we hope and they hope that there's not going to be a dispute. But if there is one, then it may be difficult. It may impede that company's ability to properly manage its affairs because they can't agree on everything unanimously. It is not uncommon. Unanimous agreements often happen, but sometimes they don't. And if they don't, it would be unfortunate in many cases to impede the operation of the company and manage the company to ensure that it's operating at its best and fullest capacity. So, as I've said, there's a lot of issues as it relates to the potential partnership disputes. There's a lot of things that can be considered in an operating agreement. It's my recommendation that these things are considered at the time that the operating agreement is drafted, and all parties have the ability to agree upon these issues so that it will resolve disputes later. Because when it's in the operating agreement, when it's in writing, when these things have been discussed and thought about and agreed upon early on, it is going to lead to less disputes, and particularly less ones that are actually going to be litigated in court. Court litigation can be costly and expensive. So can arbitration. Can be the arbitration fees and paying arbitrators can be expensive. Whereas in court, the state of Michigan is paying the fees for the judge or the cost of the judge, but in arbitration, the parties are paying for those arbitrators. With any additional questions regarding operating agreements, partnership disputes, minority oppression issues, we can be reached at bartonmorris.com, or you can find us in our office at 248-541-2600.